Hello everyone. It's me, Bisal Arel. Today, I'll be discussing about the case that we have given as part of DQ discussion question in our gap. I'll start from introduction and case summary quickly. So, it is the case of Tanner versus Grano. There are two parties in this case. Tanner and Grano, and Grano is the seller of the motor on a highway 100 means it means that Grano owns the motel on the Highway 100, and Tanner is the buyer who is interested in purchasing such a that motel. So key events here is during negotiation, Grano told Tanner the motel netted 30,000 last year. It means that the motel had made net profit of $30,000 last year, and he had the projection that the model will result in $45,000 next year. But however, the books revealed only $15,000 net profit last year, and also Grano failed to disclose that a planned bypass will divert traffic from the model. It is a significant event which needs to be disclosed, but he didn't disclose with the fraudulent intention and misrepresentation. The second fraud or second fault that he did is he didn't disclose this important and significant information to the buyer. So the outcome is after purchasing the model, Tanner discovered the actual profit figures and the bypass plan. And resulting in significantly lower profit than anticipated, and Tanner now seeks to rescind the contract and recover the purchase price, alleging fraudulent misrepresentation. So what I mean is, after purchasing and after the operation, the Tanner discovered that the actual profit was way smaller, way lower than the books and the Grano claimed before. He also figured out that the bypass plan, the shifting of bypass plan, was there from before, but he didn't disclose, and he's claiming to rescind this contract as part of fraudulent misrepresentation done by the Grano. So I will be heading towards another slide. So chances of Tanner recovering is funds. So there is a strong chance of recovery as Tanner has a high likelihood of recovering the purchase price due to the Grano's fraudulent misrepresentation. So evidence of misrepresentation is Grano said that the model netted $30,000 previously, and projected it will be 45,000 next year, but records showed only $15,000 net profit for the previous year. So this constitutes a mental misrepresentations as per the BT Samuelson and April 2023. So the legal remedy is that under the business law, if a buyer relies on the false statement that impact their decision and causes the financial harm, they may rescind the contract. The whatever information the seller provides to the buyer, and that is a significant in terms of taking the decision, then buyer actually relies on that false statement given by the seller, then it will impact in his decision, and it will if it will eventually cause the financial harm, then they may rescind the contract, and take the necessary legal remedies in order to take back such funds, such prizes to themselves. So this is the legal practice and legal remedy that the seller can actually apply. So justifiable reliance is Tanner's reliance on Grano's statement was reasonable. As per the case, we can say that Tanner's reliance on the Grano's statement was actually reasonable, as the books should have aligned with the claims made by the seller. So, like uh, books actually didn't align with the claims made by the seller, as the seller was claiming the 30,000 net profit in the previous year, but the book actually showed $15,000. There is some mistake by the buyer too, because he didn't actually check the book whether the claim was actually right, but with the misrepresentation and the fraudulent intention that the Grano had, he may made a mistake as well. So it will have impact which needs to be discussed as well. So I will move to another slide now. Did Grano commit fraud? Yes, Grano committed fraud. As per the cases and as per the analysis we can do from this case, we can say that Grano actually committed the fraud. So, intentional misrepresentation. As per this case, we can say that he had malified intention actually to induce a purchase to purchase his hotel. He actually applied intentional misrepresentation. So it is we can say that this is the fraud that occurred when a seller knowingly make false settlement. He knew that whatever he was doing. He actually knew and having a known and having the actual information that he didn't disclose, and he intentionally made this fraud, this thing. So we can say that this is a fraud. So metal impact, it not only he made the mistake, but his false misrepresentation and his false claiming had made and had provided and had the metal impact in the decision of the buyer. So the profit figure and the failure to disclose the planned bypass were metal fact. So the profit figures were significantly lower than the claim he made. The actual profit was significantly lower. The half it was half than his a claim. And he also failed to disclose the planned bypass. This was the metal factor that influenced the Tanner's decision. So deception in profit figure. So Grano's claim of prior and projected profit were knowingly false. Prior profit and the projected profit were knowingly false, as the books contradicted these figures. Grano intended for Tanner to rely on this false statement to complete the skull. So Grano intended with malified intention, he made this false statement in order to complete the sale. So we can, from this information, from this fact and from this evidence, we can say that Grano actually did fraud. So moving to another slide. Was Grano's conduct deceitful? Yes, Grano's actions were deceitful. Actually, deceitful, as we already discussed in previous slide as well. So, from his conduct and from the analysis, the deep analysis of the case, we can say that Grano's actions were actually deceitful. So, failure to disclose key information. Grano actually felt or omitted to disclose the planned highway bypass. So, the lack of good faith and transparency. So, he had malified intention to sell to made the deal of the sale. So he didn't actually disclose the material information, the material and significant disclosure that needs to be done before making any deal, before making the deal. So it shows a lack of good faith and transparency in Grano's intention. So impact of a deception. Courts often consider a party deceptive action as a ground for rescission to protect the buyer. So whenever seller intentionally made any deceptive action in order to make the sale, or in order to induce the sale, then courts often consider this deceptive action as a ground for rescission to protect the buyer, and the court rescinds the contract and does the necessary remedies and necessary works in order to return back the buyer's loss. So, effect on the case outcome is since Grano withheld information that impacted the model's value and profitability, so this deceitful strengthens Tanner's case for contract rescission. There is likely that the court will rescind this contract, and this will be considered as the deceptive action, and the court is likely to rescind the contract and take the necessary remedy to the seller in order to protect the buyer's right. We'll be heading to another slide now. The ethical eight fraudulent scenarios. So ethical conduct with uh, unintentional fraud. So what I will say is sometimes the act of a seller becomes ethical. It looks ethical, there are no intention behind the deceptive action or inducing the sell, but their action ultimately becomes a fraudulent act as per the law. In this scenario that we'll discuss now, in case of optimistic projection, everybody, seller are like a businessman, and seller are actually optimistic, and they're allowed to have such kind of optimism actually. So so they can predict that they will have higher level of profit next year, in reference to the various of that could be marketing, increment of marketing, increment of economic scenario, and with the reference of such elements or such factors that buyer can actually have the optimistic projection that they will have the significant growth in the sales in the next year. They are allowed to have such kind of optimism and projection. But having said that, they can make this kind of optimistic projection without the intention of having deception. But projection If the projection are overly optimistic and unsupported, means that if they are overly optimistic, which has no basis, and likelihood is very rare, and he knows that, and it means that there is no likelihood of happening that, and if he still does this projection, and pass on to the buyer in order to have the deception, then they can still consider as fraudulent act. So partial disclosure, and even when providing accurate but incomplete information, a seller could unintentionally mislead a buyer. It means that if the seller unintentionally provides the partial information, or disclose the partial information to the buyer, and buyer on the basis of the such partial information made the decision, which he should have known the complete information in order to make the full decision. In this condition also, it becomes the fraudulent act from the seller perspective. So unintentional non-disclosure means sometimes that they are human as well, so they may forget to disclose the critical information due to oversight, leading to financial harm for the buyer. So they may forget to disclose the important information sometimes. So this could lead to the significant harm or loss to the buyer in this condition also. Though it is ethical and unintentional fraud, but it still is a fraudulent act and fraudulent scenario that the court will consider and protect the buyer side. So talking about the conclusion, grounds for rescission, case conclusion. Grano's statement met all the elements of fraudulent representation. Whatever the Grano claimed that this case is a fraudulent misrepresentation, and he meets all the elements for each becoming the fraudulent misrepresentation actually. So in this case, there is a false claim, and there is a material fact as well, and the buyer actually relied on the falsehoods, which resulted in the financial loss for him. So result, the Tanner is likely to succeed in rescinding the contract and recovering this funds due to the Tanner's fraudulent conduct. So in this case, if this case goes to the court, then the Tanner is likely to succeed in rescinding the contract and recovering his funds due to the Granor's fraudulent conduct. So from this case, what we can take out, and what we can consider the key takeaway is that business law emphasize full transparency and honest in transaction, especially when influencing a buyer's financial decision. So there is a caveat emptor in business practice that the buyer should also know about everything, every useful information, every knowledge that needs the buyer to purchase such product, that he needs to know about that this clause is there, but with the deceptive intention, and with the malignant intention, that if the seller wants to sell that product with intentionally bad with the bad intention, then the business law has all the grounds, all the clauses, clauses about the full transparency and honest in transaction, and provides the necessary remedies, and provide the uh, uh, necessary decision in order to protect in order to protect the seller, in order to protect the buyer actually, and provides the necessary action to the seller if the action is fraudulent, and conducts mis representation, fraudulent representation, and so on. So I'll conclude this case with this conclusion. So thank you for listening.